India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals, or you can listen to them as you would a podcast. In a previous special report I filed from New York last May, I focused on the pending destruction of abortion rights in the United States. Based on public leaks from the US Supreme Court, I reported that the landmark case Roe versus Wade that guaranteed a woman's constitutional right to terminate her pregnancy would be overturned by the conservative majority that now dominates the Supreme Court thanks to former President Trump's judicial appointments. And now that this has happened as predicted, America is in social turmoil. In this week's readout, we focus on abortions in the context of women's rights in India. The debate raging on this topic begs the question, what rights do Indian women have in this country with respect to pregnancy and beyond? The comprehensively researched article is written by Shan Libby Katari, a prominent barrister who practices in Bengaluru. She is also one of India Legal's most prominent and popular commentators. In India, writes Katari, the reproductive choice of a woman has been recognized as a fundamental right by the Supreme Court three-judge panel in the case of Suchita Srivastav versus Chandigarh administration in 2009. The judges observed, Indian law allows for abortion only if the specified conditions are met. This is about 25 weeks. The Medical Termination of Pregnancy Act 1971 was modeled on the Abortion Act of 1967 of the United Kingdom. The legislative intent was to provide a qualified right to abortion, and the termination of a pregnancy has never been recognized as a normal recourse. Importantly, a woman's right to make reproductive choices is also a dimension of personal liberty under Article 21 of the Constitution of India. Katari writes, reproductive choices can be exercised to procreate as well as to abstain from procreating. The crucial consideration is that a woman's right to privacy, dignity, and bodily integrity should be respected. Reproductive rights include a woman's entitlement to carry a pregnancy to its full term, to give birth, and to raise children. However, the court went on to stipulate, in the case of pregnant women, there is also a compelling state interest in protecting the life of the prospective child. Therefore, the termination of a pregnancy is only permitted when the conditions specified in the applicable statute have been fulfilled. Hence, the provisions of the MTP Act 1971 can also be viewed as reasonable restrictions that have been placed on the exercise of reproductive choices. Now, Section 8 of the Act does come as a welcome relief to medical practitioners in this area, observes Katari. Protection of action taken in good faith, no suit for other legal proceedings shall lie against any registered medical practitioner for any damage caused, likely to be caused by anything which is in good faith done or intended to be done under the Act. Terminations are permitted when there is mental injury or anguish. In the case of ABC, daughter of Lieutenant Tilak Ban Goswami versus the state of Chandigarh, it was held that the explanation clause of Section 3 of the Act of 1971 takes within its ambit not only the physical injury but also to mental injury and anguish. It is obvious that if the victim is subjected to rape and if she is forced to give birth to a child in the social scenario where she has to face actually a lifetime of anguish, apart from the fact that the child who is born will also have to face the disdain of society. Under these circumstances, it is directed that the petitioner shall be entitled to medical termination of pregnancy. Similarly, in 2021, Justices Yadav and Sinha permitted the termination of a 14-year-old rape victim's pregnancy at just over 20 weeks. The logic was that this unwanted pregnancy is a constant cause of trauma and mental torture, and I'm quoting the judges here. The court drew a presumption that it would be a grave injury to her mental health. The Nagpur bench of the Bombay High Court earlier this year once again highlighted the principle that where any pregnancy is alleged by any pregnant woman to have been caused by rape, the anguish caused by such pregnancy is presumed to constitute a grave injury to the mental health of the pregnant woman. In 2021, Kerala High Court Justice P.B. Suresh Kumar permitted the termination of a fetus suffering from Klinefelter syndrome. I hope I'm getting this pronunciation right, Klinefelter. In this case, the wife, first petitioner, was herself suffering from mild mental retardation, visual disturbances, seizures, and weaknesses of the left lower limb with a permanent disability of 55%. Thus, although it was stated in the medical opinion that the Klinefelter syndrome is not a life-threatening disorder, in the light of the provision of Section 3, bracket 3 of the Act, it was held that the continuance of the pregnancy of the first petitioner would involve injury to the physical and mental health of the first petitioner, and taking into account the fact that the permanent medical board consisting of 8 expert doctors had recommended medical termination. The writ petition was allowed, and the first petitioner was permitted to undergo the procedure for termination of the pregnancy. Actually, the law says that the pregnancy of a minor girl cannot be terminated without the consent in writing of her guardian. In a writ petition number 659 of 2021, Justice Swaminathan of the Madurai bench of the Madras High Court was set to overrule the minor's wish to keep the child, and instead go with the wishes of her guardian, the uncle. Quote, the judge said, the minor is aged 15 years. She is not in a position to maintain herself. Her pregnancy constituted an offence by her partner under Section 6 of the Protection of Children from Sexual Offences Act, POSCO, 2012. The judges went on to reason thus. If a choice is given to the fetus now in the womb of the minor, it would definitely proclaim that it would not wish to be born, unquote. Fortunately, by this point, the girl herself had agreed to terminate, so the decision to abort was not made based on these musings. Where the 24-week mark has been passed, the courts have varied in their decisions. In writ petition number 231 of 2019, Ruma Imran versus the state of West Bengal and others, a fetus could be aborted at 25 weeks gestation because it was found to have gross congenital anomaly, hydrocephalus, I think, if I'm pronouncing it correctly again, it's a medical term, hydrocephalus, which is not compatible with normal and healthy life after birth. In Astha Pandey versus the state of Madhya Pradesh, it was held by Justice Vivek Rusia that the petitioner was not entitled to terminate her pregnancy. The reasoning was that the petitioner, a college student, and her boyfriend had broken up. But there was always a possibility of reassociation while the termination of pregnancy is irreversible. Had it been prior to the expiry of 24 weeks, the medical practitioner would have terminated the pregnancy, or the court would have permitted termination. In the High Court of Kerala at Ernakulam, Justice P.V. Asha found against petitioners Akhila Khan and Kurian Jose. Akhila Kurian and Kurian Jose, who had sought to terminate their fetus, which had serious developmental brain anomalies. However, this was at week 33, and there was the possibility of survival of the baby and excessive bleeding during the delivery. Though they were willing to take a risk, the judge was of the view that the stage at which permission could be granted had been crossed, and the writ petition was dismissed. In another judgment involving the state of Orissa, a rape victim was required to carry to term a pregnancy as it was already 26 weeks in. The police had not directed the victim and her father correctly, had not given them the right advice regarding the procedure to be followed. Harsh as this may sound, one is aware that adoption is always an option if they wish to give up the baby. More recently, however, unlike the decision made by Justice Asha, Justice Jyoti Singh in December 2021, New Delhi High Court permitted a termination at 28 weeks because the fetus suffered from a rare congenital heart disease which would lead to a substantial fetal abnormality, with attendant complications and risks resulting in a deleterious impact on the mental health of the petitioner. Also, reference was made to reproductive choices and a woman's personal liberty, enshrined in Article 21 of the Constitution of India, and thus the petitioner's inherent freedom to make this decision. Now, this is a big step away from some of the previous judgments discussed. Their rights to abort aside, pregnant women in India face severe obstacles, including access to health care, nutrition, and the physical rest that is required. They have in theory got maternity benefit, observes Qatari. These became a legal entitlement in 2013 for all Indian women except those already receiving similar benefits at government or regular as government employees or under other laws, under the National Food Security Act, NFSA. Section 4. Every pregnant and lactating mother shall be entitled to nutritious food and maternity benefits of not less than Rs 6,000 in such installments as may be prescribed by the central government. Qatari, our writer, analyzes the implementation of what are admittedly progressive measures. She writes that in practice, however, only a small fraction of applicants can avail of the newly implemented Pradhan Mantri Matru Vandana Yojana, PMMVY, Pradhan Mantri Matru Vandana Yojana. This is a scheme. This seems to have gone, but apparently the scheme seems to have gone against the spirit of the Act and provides money only to the first living child. Now, this despite the fact that India has no one-child policy as China used to have in the old days. The bureaucratic red tape plays havoc. The application form is a serpentine obstacle, 23 pages long. It is reliant on the Aadhaar ID card, which a lot of people don't have, and generally extremely cumbersome for a largely illiterate population. As pointed out by Dres, Khera and Somanchi in their article on the subject, most pregnant women in India receive substandard health care, little or no rest, and a poor diet. Some states like Odisha's Mamta scheme in Tamil Nadu have extended maternity benefits to 2 children and raised the benefits to Rs 14,000 per child, coupled with in-kind support worth about 4,000 rupees in the form of a maternity nutrition kit. As far as maternity leave is concerned, The Maternity Benefit Amendment Act of 2017 says women who have completed 80 days in the 12 months immediately preceding the date of their expected delivery are entitled to maternity leave for up to 26 weeks, of which not more than 8 weeks shall precede the expected date of delivery. Now, you've got to be a mathematician to calculate this. And an employer has to intimate women working there about the maternity benefits of the organization by writing or electronically at the time of her appointment regarding every benefit made available to them under Section 11A of the Maternity Benefit Act. An employer cannot terminate a woman after learning about her pregnancy, but unfortunately this does happen. But in cases of gross misconduct, the employer can apply the company disciplinary policy, which they often do. As of 2017, every establishment having 50 or more employees has to provide a creche with 4 visits a day to the creche by the women, including an interval for rest. Humane measures, great thinking. But as regards work from home, the employer may allow her to do so after the maternity leave, as the employer and the woman may mutually agree. It doesn't under the best of circumstances. People tend to ignore these rules and regulations made in the best of faith. Now, Qatari concludes that pregnancy and subsequent decisions are fraught with uncertainty. But Indian women are nothing if not resilient and stoic. Life goes on. I don't think anybody could have put it better or more succinctly. Thank you, Shan Qatari, Libby, for enlightening us. This is your host, Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.